Hi, everyone, and welcome to Everything About Wealth, the podcast. This podcast is focused on wealth building, and I am your host, Denny Troncoso, and this is episode number 7. If you were with us on the last podcast, episode number 6, Desi and I went over the BRRRR strategy to investing. It is a great episode, so make sure to check it out. In this episode, Desi and I interview Securities Attorney Gene Trowbridge. Gene reviews rules and regulations about raising capital that investors that are putting capital to work should be aware of when working with syndicators. If you don't already, make sure to follow us on Instagram, Facebook at Everything About Wealth. I'm here with my business and life partner, Desiree Troncoso.
Hi.
And today we have the privilege to be interviewing Gene Trowbridge. And Gene Trowbridge is a securities attorney. He's a California licensed attorney, real estate broker, and author. And he is the founding partner of the corporate securities law firm Trowbridge Sidoti, LLP, or crowdfundinglawyers.net. In addition to his law practice, Gene is a preeminent educator in the world of real estate and syndication. He served as a senior CCIM instructor for a number of years and has written a great book that's very comprehensive on syndication called It's a Whole New Business. Get the 3rd edition because there's several editions. And without further ado, Gene, are you there?
I am here. Hello, everyone. Hello, Desiree. Hello, Denny.
Hey, and thanks for being on the call with us, Gene.
You're welcome.
Now, I know we have a lot to talk about today, but can you tell us a little bit about yourself and how do you get into securities attorney and then syndication?
Well, the short version of it is I've been in the commercial real estate business since right out of college. And for really the first half of my career, I was a syndicator. I put together my own deals, primarily in the area of building storage facilities, self-storage facilities in Southern California here. And when I was 45, I decided that I would go to law school to improve myself. And when I came out of law school, I decided that I could be a lawyer in the area of securities and syndication. And so that's what I've done for the last 20 years.
Wow. Not that long, just 20 years or so.
Just 20, yeah. I'm not going to tell anyone how old I am, but let's see, 45 and 20. Here we go.
We can just leave it there.
Why don't we? Because I think I'm even undercutting it. I need to work on my numbers. I think I've been an attorney longer than I just mentioned, because that only adds up to 66, and I'm counting myself short. There we go. Okay.
Well, excellent. So I know that syndication is a pretty, people think it's a different things. They have a different understanding of it. Can you give us the explanation of what is an actual syndication?
Well, a syndication is when 2 or more people or companies get together to do some business transaction and combine their resources. Examples I usually give are when you go to the movie. At the beginning of the movie, you see, Fox, Searchlight, and a couple other names of companies that are getting together to put the movie together. That's a syndication. Some of them bring in money, some of them bring in expertise. When you fly on an airplane, really that's a syndication. Commercial airplane, you don't have a pilot's license, you don't own a plane, but you hire someone who does, and you get where you're going. So that's simply what a syndication is, and we do that a lot in our business. When you go out and look at commercial real estate, and you look at the ownership of commercial real estate, almost every time you look at it, the real estate is going to be owned by some ownership group, not Gene and Kay Trowbridge as family, as community property. It's going to be owned by an LLC or a corporation, and those are syndications. So it's very, very prevalent in the world of commercial real estate.
Yes, it is. And one thing that Denny and I get a lot of questions on, because I think it's maybe the new popular word, is crowdfunding and syndication. And a lot of new investors are thinking it's the same thing. And as we know, there's differences between the two. So could you give, we're going to go into a lot more detail later on, but how would you let someone know what is the difference between crowdfunding and what a syndication is?
Well, first of all, everything is a syndication. When you pool money to buy a property, it is a syndication. The question is, where does it fall under the securities law rules? And it may fall under the securities laws rules that are called crowdfunding laws, and it may just simply fall under the private placement rules. So in the Jobs Act that came out in 2013, Congress used the word crowdfunding for a very, very small portion of the Jobs Act, but it's such a cool word that everyone has decided to adopt it in their business. In fact, we even changed our website marketing from syndication lawyers to crowdfunding lawyers. We're still doing the same thing.
Right.
The same thing I started doing in 1972. We're putting together syndications, but crowdfunding is just a fun word. Not to say that this is really anything new. You've all heard of GoFundMe, where people say, I want a vacation, I want braces, I want whatever. And so they go to the public and the public just sends them money. Mm-hmm. Well, that's crowdfunding, but that doesn't have anything to do with the business world. Mm-hmm. The Jobs Act took the word crowdfunding and took it into the business world and tucked it in underneath the securities rules. So I think they're synonyms. That's a long answer to the question. I think syndication and crowdfunding are synonyms unless you're working under one particular part of the law.
Got it. That makes a lot of sense because it is a cool word that people are asking a lot of questions about, but it basically means the same thing. Now, you went in a little bit of the explanation of, you kind of answered this next question of why is it important to hire a securities attorney, and talk about maybe complexities with the law and going through the process. Can you give us some more information on that?
When you put your group together to buy something, if there's someone who's in charge, a general partner or managing member, that makes it a security. Now you have to follow the securities laws. So now you have to go out and find someone who practices in the area of securities. There are a lot of attorneys out there, but they don't do securities law. Okay, there are fewer attorneys who will do securities laws as their practice. Many large firms don't allow their attorneys to do securities law because of their errors and omissions insurance doesn't allow it. Mm-hmm. And many single practitioners don't do securities laws because the errors and omissions insurance is so expensive. I'm not saying they don't know what the securities laws are and they couldn't do the work, but there are some barriers to entry to be a securities attorney. And our firm, this is all we do, and we buy the errors and omissions insurance to protect us and our clients in case we make a mistake. So it is important to have, it's like going to a foot doctor if you need your teeth cleaned. They're all doctors, but they do different things, right?
Yeah. Mm-hmm. Now, I know we mentioned securities attorney, but can you just give us a brief of what is an actual security?
Well, a security is, plain English, when investors pool their money into a common enterprise like an LLC or a limited partnership, and they're doing it because they expect a profit. This is not just a gift, it's a profit. And someone's in charge. Someone is going to make it happen. So we're going to have a manager, we're going to have a general partner, and then we're going to have passives. The passives are either limited partners or members. And because there's someone in charge, government is interested in protecting the passive investors and created a whole series of laws to govern the sale of a security. So it's an investment of money in a common enterprise with an expectation of profit, and the profits are going to happen through the results of one particular person or one particular group. That's a security.
Yeah, and I think that brings up a good next point that we like to clarify, and I know we've actually had this conversation with you previously as well, is when is it necessary to actually syndicate or where you can just have a joint venture? And I know you just mentioned when somebody's in charge. So could you go into a little bit more details about that?
Sure. Well, Desiree, a joint venture is still a syndication.
Yep.
It's maybe two people pooling their money. The question is, does your syndication rise to the level of a security?
Right.
That's a totally different question. And if you had two or more, let's say 2 or 3 people pool their money, pool their expertise into a project, and they formed an LLC, and they were all equal members, and all the decisions were made unanimously, that would certainly be a syndication, but it's not a security. They invested their money in the common enterprise. They wanted to make a profit, but there was no individual or group who took charge of their money. Mm-hmm. They took charge themselves. So in legal terms, we would call something like that a member-managed syndication. That's where the members make all the decisions. Mm-hmm. If it's manager-managed, that brings in the fourth prong, which says someone else is running everything. And so that's a manager-managed syndication, which is a security.
So what are the implications? A lot of people talk about joint ventures, and I see that you just explained it. If it's manager-managed, then it becomes a security. If they didn't go through the correct process to hire a securities attorney to do the proper disclosures, et cetera, what are the implications of not following that? And talk a little bit about what the process entails with someone that would hire you as well.
All right. If I was going to be hired, or any security attorney was going to be hired, of course you'd start with a fee agreement and a payment of the fee, and then we'd have an interview process with you where you would tell us about the deal and what's going on in the deal, and then we would develop first of all, we would determine if your plan was to have it to be a security or not a security. And if it's not a security, we just simply stop and form an LLC or limited partnership and let you go forward. Mm-hmm. Relatively simply. But if it's a security, once we get the entity formed, then we have to follow the securities laws. And the major tenet of the thousands of pages of securities laws is that you have to give the investor all the information they need ahead of time so they can make an informed decision. You have to give them all the material facts. That right there tells you why I, as the securities attorney, would be drafting a private placement memorandum, which is the story of the transaction. That tells the investors all the things that are going to happen during the transaction. And then I'd attach to that the operating agreement, which are the rules by which the group works and by which the manager operates. And then there's a subscription booklet, which has 2 parts to it. One, the investor says, hey, I'd like to send you a check. Will you accept my subscription? And the second part is a questionnaire that the investor fills out to give the syndicator information about the investor so that the syndicator can make a determination on whether the investor is suitable for this investment. Now, going back to the first part of your question, why is it important? Well, the securities laws, that's a criminal statute. So if you don't follow the securities laws and you are found to have violated the securities laws and put together a group and sold what you thought was a joint venture, and and not a security, and it turns out that it was a security, you could suffer quite a bit legally. Dollar and cent penalties. You could go to jail. There are all sorts of things that could happen to you. So it's clearly a criminal statute. So we need to do it right. We need to make sure you do it right and keep you out of trouble.
Yes, exactly. And I think that's why we made sure to contact Gene when we were trying to do a syndication to make sure that we were doing everything per the book and correct.
And it just gives you peace of mind when you hire the right person. You're doing things correctly. You can be confident in the way that you're doing things.
No, I think that's important. Yes.
Okay, so we were talking about the different ways that you can raise money, and you have there's different parts of the law of what I understand. There's the 506B, 506C, and mini IPO. And I know it can get really technical with the different options, but can you give us an idea of some of the basics of each option and maybe which one you would recommend for a new investor?
Sure. The securities laws were designed to protect the investing public from investing in deals that were bad, primarily because there was no information given to the investors before they invested their money. That was really the first thing. And the second thing was to protect the investors from people who were selling fraudulent investments. And there's a whole licensing area of the securities laws that has to do with salesmen. And generally, we don't get involved in that. We're much more involved in the development of the documents to tell people what's happening. And in the government's goal to protect investors, they decided that there were a lot of investors who really didn't need their protection. If we had a limited amount of time and a limited amount of manpower and a limited budget, we'd want to just protect the people who needed our protection, not the people who were rich and smart. So the government put together a format that involved the definition of an accredited investor. An accredited investor, someone with over $1 million, or someone with over $200,000 or $300,000 of annual revenue. Those people, the government didn't think they needed to protect, so they wrote a part of the law that says if you're going to deal just with accredited investors, the law is a little more lenient toward the syndicator. The other thing they talked about is, let's keep this private. Let's keep this where people know who they're investing with, both sides, the syndicator who knows who the investors are, and the investors who know who the syndicator is. So that all came down in a law called Regulation D as in dog, Regulation D, Rule 506. And since 1981, that's been the rule of the land. You could raise as much money as you want from as many accredited investors as you want. You cannot do any advertising and solicitation. And because you know the investors, because you're not advertising, we're also going to let you take 35 people who are sophisticated. They might not meet the $1 million net worth level or the $200,000 dollar and cent income level, but they're educated, they're smart, they know about investing, they know about real estate. We'll let you take up to 35 of those people into your deal. So 506 has been unlimited dollar amount, unlimited accredited, 35 sophisticated investors, no advertising or solicitation. And in the Jobs Act in 2013, the government thought that that was a little restrictive, that if we really believe that all the rich and smart people didn't need protection, why wouldn't we let syndicators advertise to the rich and smart people and let the rich and smart people read the documents, make a decision for themselves on whether the investment was okay? We wouldn't let you advertise to people who weren't rich and smart, who were just sophisticated. We wouldn't do that. So they created 506C, And 506C says raise as much money as you want from as many accredited investors as you want. And you can advertise and solicit, but we're going to have to do some background checking on the investors to make sure that the people who go into your deal are accredited. Well, that really opened up the world to different types of solicitation and advertising. You know, Denny, there's about 1 million accredited investors in the United States. There were about 3 million before Dodd-Frank came along and said in the $1 million net worth calculations, you can no longer take the value of your primary residence. So that cut the number of accredited investors by 2/3. But there's still 1 million people out there. And if you want to advertise and go to those people you don't know, and you have a good story, and you have a good track record, you can raise money from them. However, most of the people, as you know, still count on the people that they have a relationship with to raise money from. And the most recent statistics are out there are from 2018, and about 95% of the syndication money, the securities money that was raised, was still raised under 506, under the old rules, with 35 investors, no advertising. And that's called the 506B. So it's confusing. 506B, the old rules, no advertising, 35 sophisticated investors maximum. 506C, advertise all you want, take all the accredited investors you want, but you have to do some background check to make sure the people who invest with you are accredited. Then there's the crowdfunding. The crowdfunding that came out of the Jobs Act allows advertising to non-accredited investors, but you can only raise $1 million. So it's very insignificant in the world of real estate syndication. Actually, the number one business venture that takes advantage of crowdfunding is IPAs, private brewing companies. Someone decides that they can make a great batch of beer in their house, but if they had $250,000, they could go down and rent a warehouse and buy some equipment and make some more beer. And so that's the number one business in the world of crowdfunding. And they can get $250,000 from almost anyone. They can advertise. They can get it from almost anyone. The only issue is they can't take more than 10% of an investor's net worth. So it's limited in dollar amount in the total and limited in dollar amount on an individual level. So that's it. There's a 506, B and C, and there's crowdfunding.
For the 506B, you had mentioned the pre-existing relationship. Can you go a little bit more into detail exactly what that means? Is that someone that,
all right,
that I've talked to briefly?
Sure. The whole issue there is pre-existing. That's the word. And what does pre-existing means? It means that the syndicator has a relationship with a potential investor prior to the start of the offering. And you start your offering when you hire an attorney and you sign the fee agreement. So from the time you sign the fee agreement, if you come into contact with a new investor, someone you didn't know, you didn't have a pre-existing relationship with, in order to protect yourself from a claim that you advertise and you're solicited to get that investor, which is part of 506B, right?
Right.
You protect yourself by having some sort of a record-keeping system, knowing that this person was someone you knew and the relation prior to your offering, therefore the relation was pre-existing. Now, in 506C, when you advertise, no one cares about that because you can just simply advertise. But in 506B, you have to have that pre-existing relationship.
What about the option that you can raise money from unaccredited investors, Gene, and that there's, I think it's $25 million or $50 million that you can raise, or something that's...
Oh, the big one, yes. Regulation A+. Regulation A+ is actually something that was expanded broadly in the Jobs Act also. And in Regulation A+, it's a little more technical. You have to go to the SEC You have to show them all your documents, all your advertising, all your pro formas and everything. And if approved, they will give you a permit. The permit then lets you advertise and take money from anyone. Once again, probably limited to 10% of their net worth, and you can raise up to $50 million a year. Okay, so that $50 million limit is a limit because now we're allowing people to advertise and take money from non-accredited investors. So we have to somehow limit the amount of risk that we're putting into the marketplace. Where in Reg D, because primarily we're dealing with accredited investors, there's no limit to how much you can raise because most of the people are rich and smart. They can fend for themselves. But that Regulation A, Jillian in our office pretty much does Regulation A, and the total costs, including legal and audits and all that, probably $75,000 to $100,000. And the timing on that is 4 to 5 months to get your permit. The way it's used in real estate is in a blind pool, where you have a good track record of doing something, flipping houses, and now you want to go out and raise $25 million to flip houses and you want to raise it from non-accredited investors that you can advertise to. That works. But most of our Regulation A offerings aren't real estate at all. They're racehorses and cannabis and patents for medical equipment and the construction of solar panels, things like that aren't time sensitive like a real estate closing is.
Got it. You actually jumped into something I was going to ask you, which was the blind pool. And I know you mentioned having a track record, you're doing flips, you want to raise a lot of money, so you can just go out and raise and buy single family homes for the blind pool. Some of these offerings, which is what we did with you when we hired you, it was actually for a single asset entity for a single purchase. And could you just talk a little bit about that and also explain what you would recommend for a new investor to start with?
Sure. Isn't it funny? This is quite a vocabulary lesson this hour that we're spending together. This part of the question, this part of the discussion has 3 vocabulary terms. A specific offering. You two went out and did a specific offering for a specific property, and I, as an investor, could drive by the property, could look at all the numbers, and I knew exactly where my money was going. Specific offering. Now, after you've done 5, 6, 7 of those, and they're all in the same category, multifamily, you could come out with a blind pool. Right. And you could say to your people, we don't have a property to show you right now, but here's our track record. Here's our investment summary and our business plan. We're going to go out and raise enough money maybe to buy 4 or 5 of those properties. Blind pool. The investors have no idea which properties you're going to buy, but they're investing on you, your track record, and your business plan. And then you take the money and go out and buy what you told them you were going to buy. That's okay. Then in between, it's called semi-specific. And this is what a lot of house flippers do. Gene, we want to raise money to buy 100 houses. We've got a great track record doing houses, and we've got 5 under contract right now. So we want to tell our people, here's our strategy. We've already identified the first 5 properties in the strategy, and we're ready to close on those. And then we're going to go out and see if we can buy another 95. So that's called semi-specific. I suppose you could call it semi-blind, but in marketing terms, semi-specific sounds better. If I'm an investor with a first-time syndicator, I'm going to invest in a specific offering. That's my advice to investors. If I'm a first-time syndicator and I'm a little concerned about my ability to raise money, I'm going to do a specific property because it'll be easier to raise money on the specific property. As a syndicator, as I get better and better and do more and more deals, there's a real advantage of putting multiple properties in one fund. It's diversification. You can buy one property, and if it goes bad, you're screwed. You could buy 3, and if one of them goes bad, well, hopefully the other 2 will bail you out, right? So in the hierarchy, specific is the easiest money raising, semi-specific is the second easiest, and blind pool is the third, and vice versa in the area of risk. I think specific probably is the least risky for a passive, and a blind pool could be the most risky. However, there's that track record out there. And if the track record is good and the sponsor is good, that may not be risky at all. I don't know.
Great information. Very important. I know it's a little bit technical with the securities. It's not something you want to jump up and down. At least I do, but maybe not not most people, right? When you're learning about the rules and the regulations, but it's very important to do things right.
Right. And you can have an idea of it, but also that's why you should call Gene or another security attorney to verify what the best way to move forward with your strategy will be.
Mm-hmm.
Yes, most securities attorneys will talk to you, do a consultation up front that doesn't cost you anything. And let me suggest this: if you were out there and you were looking for a securities attorney, this would be the people who are listening to this who want to do their own offerings. Mm-hmm. If you're looking for a security attorney, one of the ways to find one locally that I found works is you call the local bar association. Let's say you're in Philadelphia. You call the Philadelphia Bar Association and tell them you'd like to talk to either the real estate section or the corporate section. And they'll give you, every year there's a volunteer who runs one of those sections, and they'll give you the name and number of that volunteer for that year. You call that volunteer and say, I'm looking for a securities attorney. I'd start with the real estate department first, because if you go to the corporate world, there's a lot of securities that are in the corporate world that don't have anything to do with real estate. So that might not help you as much. But if there is like myself, I'm a member of the real estate section of the Orange County Bar Association and do securities work. So I'd be the perfect person for a local person to call. But if you called a corporate guy, that might not be the right person.
But your firm, you operate in how many states do you operate?
Oh, everything is federal law. So we operate throughout the whole country.
Okay. So anyone even in Philadelphia, if they'd like to and feel comfortable,
sure,
with you, they could contact your company.
Sure.
Excellent.
I think that brings up a good next question to ask, because we were talking about how to contact security attorneys. When in the process of the acquisition should an investor contact a securities attorney to get started? Because I know it takes some time to prepare all the documents.
Right. I think that you and I probably know that it takes 3, 4, 5 weeks, right? 3, 4, 5 weeks to get all the documents together so you're out talking to the investors and raising the money. In my practice, I like someone to contact me when they have a letter of intent signed for a property. I'd at least like to start the dialogue at that time. From the letter of intent, the client goes on to the purchase and sale agreement. When that purchase and sale agreement is executed, we need to be up and running. Right? So that's how I think we should get started.
Got it. And you mentioned the process of hiring your office at the beginning a little bit, but can you talk about some of the next steps? So we already signed the engagement letter. I know there's a lot of back and forth with your office reviewing some of the documents, the subscription documents. But when after the fact, there's also some things that need to be done even after you close on the property. Can you talk about that?
Okay, so you hire us, we interview you to get all the information we need to start writing your documents. We get a draft. The way I work is I do a draft of the PPM, which is kind of the story, and I send you the story in a draft form, and you read it and say, well, Gene, you've got this right or you've got this wrong. Then once we get the story done, it's easy for me to draft the operating agreement, which is the rules. on how the group is going to be run, and then the subscription agreement. And then we head off to get financing. And during the financing, there's probably some things that the lender wants. Maybe they want the document changed for their specific language, for some different clauses, and they might want legal opinions on certain things. And you probably are going to have to get a real estate attorney involved in that part of it, because that's most securities attorneys don't do the real estate law, the real estate closing. Mm-hmm. You'd have to be licensed in the state where the property is to do that. So like you guys are in Florida, so you used a Florida attorney to handle real estate closing. Mm-hmm. I did securities work. And then after you close the deal, you've got to communicate with your securities attorney's office, because now the securities attorney has to file a document, an information document with the SEC called a Form D, and then send notices of securities sales to the states where you have investors. So Florida would get a notice that we've sold some securities in Florida, and if you've got an investor from Georgia, we'd send Georgia a notice. Those state notices are important for the states, so that if a resident of a state wants some information as we go forward on what's going on, they're going to call their state securities office. And the state securities office needs to know how to get a hold of you.
Got it.
So within 15 days of of spending their money, let's use that, 15 days after spending the money from the investors, we have to tell each state that we've gone into their state and we've raised money from some of their citizens.
Got it. And I think what you're saying, everything that you're saying here is just reconfirming the importance of contacting a securities attorney. And even I would even recommend, I highly recommend Gene, of course, but it's very important to do things right and stay legal and compliant. Right. Yeah. And with that, we're closing.
Can we talk about some mistakes syndicators make?
Oh, that's exactly what we're going to ask you next. What are the?
I had a feeling you were leading me on with that. Yeah. The number one mistake a syndicator makes is trying to do these documents themselves. Mm-hmm. Yeah. The number two mistake my clients make is they don't read the documents that they hire someone else to do.
Yes.
Man, oh man. And the number three mistake is probably not giving yourself enough time. Uh-huh. Now I want to talk about mistakes that investors make, because you've got people listening to you who are passives. Okay. The first thing an investor has to ask when they see a syndication that they might like to invest in, they have to ask the syndicator, Denny, if I give you my money, what happens if something happens to you? Number one question. What's your plan for continuity in case something happens to the manager? Because the manager signed the loan. The manager in the operating agreement is the only one who has the authority to sign documents, not the property management company. They can't borrow money. They can't do anything. It's the manager. So what did you guys do? You said, Gene, our continuity plan, it's the two of us. It's Denny and Desiree. Okay, cool. Now I'm comfortable. Okay. The second question an investor should ask is, have you done this before? I bet you got that question when you were raising money for your first deal.
Yes,
definitely.
Right? Yes.
Sure. And every one of us, including me, has had to say no once, right?
Mm-hmm.
Right.
So that doesn't mean you shouldn't invest with someone who has never done it before, but you might have to, as an investor, delve in a little bit deeper into what exactly is their training and their background. Have they invested in properties themselves? I mean, syndication is a different business, and that's what my book is. It's a whole new business. I tried to write that for people who think it's just the real estate business, but it's not. It's the care and maintenance of investors under the securities laws. So you can have a lot of real estate experience yourself, but not have done the syndication. And I wouldn't hesitate to invest with someone like that, but at least I'd want to know, have they done it before?
Right.
And then as a passive investor, I'm going to ask, is this deal good enough that you're going to invest some of your own money? And the answer should be yes. I don't know how much is enough. If you came out with a $50,000 minimum where each investor had to invest at least $50, I don't think the sponsor has to invest $50. I think if the sponsor invested $25, that'd be fine. Mm-hmm. Kind of a marketing question. We don't want the sponsor to invest all their money in the first deal because then they can never do another deal.
That's right.
And if it's going to be a good sponsor, the investors want the sponsor to do many deals so they can invest frequently. Okay? What were you going to say, Denny?
No, I was agreeing with you. You can't, if the sponsor invests all their money in that deal, there's no more after that one.
Right. And then the last question I would ask as a passive is there anything in the documents that explains if I, as the investor, need my money out of the deal, how does that happen? Because, these are non-liquid. They're not traded on the stock exchange. They're non-liquid. But there are provisions in the operating agreement that will help in time of a need, help the investor see that there is some possibility that they can get their money back.
And with finishing up our last question, could you talk about the 3 actions that successful syndicators take? Okay.
The first action a successful syndicator takes is to find someone to do this with so they solve the issue of continuity. Mm-hmm. Okay. That protects their investors. The next thing I think they need to do is treat this as a business. This syndicator is in charge of the investor's money. Fiduciary duty. So treat it like a business.
Right.
You owe it to your investors. Probably, you've heard me say at my workshops, you probably have to treat their money better than yours.
Yep.
Okay?
That's right.
And that's good. And then don't think you're going to get rich. Successful syndicators know that if they get paid, which they should get paid, but they get paid along with their investors. As their investors are making a profit, they're making a profit. You're going to have a long and successful career as a syndicator, and your investors are going to do very well investing with you.
Awesome.
Yeah, I think that was a great point, Gene, and I appreciate the feedback. Do you want to go ahead and give everybody your contact information or website where they can reach you?
Why wouldn't I? Sure. Sure. My name was Gene Trowbridge, and our website is crowdfundinglawyers.net. One word, crowdfundinglawyers.net. So my email address is gene@crowdfundinglawyers.net. My direct phone number to my private office is 949-855-8399. That covers it.
Excellent. Gene, we appreciate you taking the time to be with us today, and we look forward to doing many more syndications with you.
So do I. Thank you, Desiree. Thank you, Denny.
Thank you. Bye-bye.
Thanks for tuning in. I hope you enjoyed hearing from our expert on capital raising, Gene Trowbridge. To learn more about real estate investing or how to be a capital partner, visit our website at www.everythingaboutwealth.com. If you like the show, please make sure to subscribe and like us on iTunes or your favorite app. With that, see you on the next show. Take care.